Good afternoon, good morning, depending where you are. It's a pleasure to be with you today. Welcome to this webinar, a new webinar on the impact of artificial intelligence on children's rights and child justice. So it will be a short webinar, very interesting with a bunch of very good experts, and we will have this discussion during around 50 minutes. So grab your sandwich, your Pokeball, and join us. And I hope you will learn a lot of things. So today we will focus on technologies, artificial intelligence, and child justice system. But before to enter into the content of this webinar, just wanted to tell you a little bit more about some housekeeping. So you can use the chat and ask all the questions you want to our distinguished panelists. This webinar is of course recorded and will be available later on our YouTube channel. And we would end up the webinar by a poll. So we invite you to stay with us 2-3 minutes at the end. So you can share with us your experience. So let's start. I'm Cédric Foussard. I work as advocacy and learning advisor at Terre des Hommes Foundation for the Access to Justice program. I'm also the coordinator of the Global Initiative on Justice with Children. So we are organizing this second webinar in the context of a EU-funded project, the I Access My Right project, that my colleague Dora will tell you a little bit more just after. So the first webinar took place in March, if I remember well, and focused on technology, artificial intelligence, and child justice system and the implication for children human rights. And we had a very vibrant discussion around topics such as facial recognition and child right impact assessment. But today is a different topic. Today, we're going to speak about this EU Artificial Intelligence Act, which is a proposed European regulation on artificial intelligence. And it will be the first comprehensive regulation on artificial intelligence at global level. So you might be aware a little bit about this act. It focuses on different risks of artificial intelligence, those which are unacceptable or high risk application. And the question that we will formulate today with our experts is to know if children's rights are considered in this act. So initially, to say the truth, the first draft did not include much about children. And the last version, fortunately, underlined a little bit more about children's rights. The last versions underline the importance to consider children's specific needs when developing and deploying artificial intelligence system to avoid adverse impact by such system on their fundamental right. So in a way, it is a small victory. Nevertheless, there is, for the moment, no guidance about how to implement this recommendation. So let's speak about that today with our speakers. I'm very pleased to present you my colleague Dora Kiss. She's coordinator of the I Access project. We have as well Victoria Hendricks. Victoria, good morning. She's a PhD researcher at KU Leuven, Center for IT IP in Belgium. So Victoria focuses on the impact of artificial intelligence and judiciary. And for the I Access project, she researched legal and ethical consideration in the development of AI-driven chatbot. And then we have Nessa. Hi, Nessa. Nessa Lynch. She is lecturer in law, innovation, and technology at the University of Cork in Ireland. And she is as well research fellow at Victoria University in Wellington in New Zealand. And she has expertise in both law, of course, and emerging technology and youth justice, and particularly in biometric surveillance. And perhaps Nessa will tell us a little bit more about that. So with that transition, I give you the floor, Dora, and thank you again for organizing this webinar.
Thank you, Cedric. Let me quickly share my screen, and then we can start. Okay. So as a start, I would like to tell you all a bit about the project that we are working on and around which this webinar is taking place. So the project is called I Access My Right. And the goal within this project is to explore the potential of artificial intelligence to increase children's access to justice. The project has two main pillars. One is the design and development of an AI-driven tool, a chatbot, which we already mentioned. And the other one is to run a series of EU and national level awareness raising and advocacy to discuss this very important but also emerging topic and figure out how to contextualize it within the child justice system. The project is funded by the European Commission, as mentioned before, the Justice Programme of the EU, and it's implemented between 2023 and 2024. Therefore, it's running until the end of this year. It is taking place the local implementation is taking place in Bulgaria, Greece, and Romania. And the consortium is consisted of PDH Hungary as the lead, Terdezom Hellas as implementing partner, as well as Terdezom Romania as implementing, and the Social Activities and Practices Institute from Bulgaria. In addition to this field implementing organization, we also have KU Leuven on board, who is assisting the consortium with indeed the ethical and legal considerations to develop such a chatbot. And we have Loren on board, who is a legal tech company, and they are in charge of the technical development of this tool. And we also have Noldus, who are assisting us with user requirements assessment and the monitoring of user experience during the interaction of children and the chatbot. And now I would like to talk especially about the chatbot itself. If you would like to learn more about the project, please watch our previous webinar, because there we are talking a bit more about the general idea of the project. But here I would like to discuss the chatbot itself. And then afterward, I will hand over to Mike to Victoria to actually include how our chatbot is qualified under the AI Act, because this has been something which is quite new. So the AI Act was adopted during the implementation of the project. So back when we started, there hasn't been any specific legal consideration which we had to take into account for the delivery of this tool. But during the implementation, the AI Act has been changing, and there was this long trialogue process on an EU level. But eventually, we now have the final text, and we know how to proceed from there. So basically, the idea of the chatbot is to deliver and provide access to children to reliable, age-appropriate, and child-friendly information about their rights and the available support services that they can turn to if they are in contact with the law, especially as victims of crime. And considering that there is a merge of considerations which needed to be taken into account during the development and design, because on one hand, it involves children. So we need to make sure that we adhere to children's rights consideration, but there is also the digital development angle, which also comes with a lot of consideration. So as you see, we had to consider how to implement the do no harm principle within this project, the safety by design principle, the privacy by design principle, also with the participation of children, which is inherent to all of our operations as a child rights organization, and also ensure that we are conducting this process in an environment where all the relevant stakeholders has a say. So this basically goes back to the consortium setup, because within the consortium, we have the child rights experts, we also have the technical developers, we have the ethical, an actor basically providing us to implement all the ethical and legal considerations. Everybody has the same voice around the table. So we make sure that we are not bound by sort of contractual obligations that we cannot really implement what we consider would be the best for children. So basically, the consortium setup really provides a great environment to implement this project. And considering the process, the design and development process really followed a product delivery mindset. Those of you who are familiar with product design and product development processes will be familiar with the phrases of user needs assessment, use case development, and these phrases, which basically mean that from the start, we started with mapping the needs of users who are children in contact with the law. We asked them a series of questions about what they would like to use this tool for, what would be useful for them in the future. And based on this, we conducted these interviews with almost 25 children per country, so overall 75 children. And we also consulted with lawyers and child rights professionals on the field in the 3 countries where we are implementing. And afterwards, based on these results, we set up a list of requirements. What are the basic requirements that children and other stakeholders would expect from this tool? And then afterwards, we moved to the development of use cases. These are basically specific scenarios, imaginary scenarios where children might encounter this tool and use it. For example, we have a use case where a child is being bullied in the school, and we mapped what kind of questions would these children ask from the chatbot and what kind of response we as the human professional would like to see the chatbot deliver. And these use cases will be serving as a validation tool. So therefore, during the end of the development process, or where we consider that we are close to the end of the development process, we can compare like what kind of response the chatbot is giving and what was our human setup, and see how the chatbot is working and whether it delivers the result that we are expecting. And this followed by the technical development, which is entirely the responsibility of our partner, Lauren. And this follows with a lot of round of testing and iteration with adults and also with children. In the next, I will also talk about where we are at the moment with the chatbot development. But first, I would like to discuss a very important topic relating to distinguishing between what this tool can do and what it cannot do. Because during the design phase, we realized that there are a vast of opportunities where we can go to with this chatbot, but we need to take into account a lot of things, which is, I mentioned before, the do no harm principle, the safety by design, the privacy by design, ensuring that the data that children use are being handled responsibly, and so on. So we basically had to distinguish between what is a necessary element of the chatbot, what are the nice to haves, and what are the things that the chatbot cannot deliver at this stage. And the chatbot is going to provide general legal information to children between the ages of 13 and 18. It's very important to distinguish between general legal information and like personalized legal advice and legal assistance, because that would require a lot of personal data that would also put ensure like we need to also take into account liability issues, like who would be responsible for the provision of such advice. Therefore, this tool is limited to general legal information based on the legal act and all the provisions that we uploaded in the source base. It will also deliver information about the available support services in the respective countries. It is mandated to be primarily used by child victims of abuse and crime. And it is designed for children who are already in contact in some ways with the actors of the child justice or the child protection system. Therefore, the idea is that a trained professional will introduce this tool to a child who is being handled in the child protection sector. And in order to properly understand what is the chatbot going to do, we need to consider what it's not going to do. So it is not mandated to be a standalone solution which a child can use without any additional collaboration from the actors of the child protection or the child justice sector. It doesn't provide individualized legal assistance. And it's also not a referral tool, so it doesn't automatically refer children to the services listed down in the answers. It will be up to the children's agency and the environment who is protecting or like assisting the child to actually go to these services if they decide to, because this is also really important to give back the agency to the children who are using this chatbot, because such a technology cannot immediately take out the agency from the child's hand and without any consideration just submit a certain file or claim to any of the actors of within the referral system. It also doesn't conduct individualized needs assessment, because this is something which needs to be carried out by trained professionals at the first contact with the specific institution. And it is also not mandated to replace any human professionals, only to sort of assist them during the interaction with the children. Therefore, they can turn to this tool and ensure that tool is going to provide child-friendly and age-appropriate legal information to children. This is also super important, because what came out from the user need assessment, that sometimes children feel more comfortable with asking questions from a chatbot or from a digital tool, rather than talking to all those numbers of human professionals that they don't really trust at the moment of encountering them. And this tool serves as a solution for this specific problem, but it's not going to replace any human assistance. And considering where we are, because as I mentioned, and probably you can imagine, a lot of preparation had to go into even delivering the concept note for this tool and the first prototype. But eventually we have completed the development of the first prototype. So at the moment it is being tested in Greece, Romania, and Bulgaria, with approximately 25 adults who are working within this sector. And they are providing us information about whether they think that the tool is accurate, the answers are correct and clear and understandable for children. Is it child-friendly enough? Is the tone and the wording of the response accurate? And based on these results, we will go back to iterate the tool and propose lines of iteration and validate this with the Project Technical Advisory Board, who is a group of external experts on the territory of technology and children's rights. And after this iteration process, the second prototype will be tested by children, also in Greece, Romania, and Bulgaria. And the same process will follow, that the results and the lines of further iteration will be validated by the Project's Technical Advisory Board. And then afterwards, we'll turn to the delivery of the final product in all the 3 countries. During these processes, we parallelly put a lot of focus on mapping sustainability solutions, because as you can imagine, the development of the tool is not the end. We would like this tool to be used in all the 3 countries and potentially consider maybe expanding the coverage and covering more countries. But for that, we need to make sure that this tool is used by all the professionals, is being presented to children, and all the comments and all the considerations that the adults and professionals are adding, and as well as children, are being taken into account and being delivered in this tool. So as I will now hand the floor to Victoria to actually qualify this tool under the AI Act, because it's been a huge journey to actually deliver something and also translate those provisions that are now outlined in the AI Act to actual actionable solutions that we can we can implement through technological means, but also by taking into account the child-specific considerations. And yeah, thank you so much. And if you have any questions, please just throw them in the chat and we'll try to respond.
Hello, thank you so much for the introduction and for the invitation to take part in this webinar. And so for today's webinar, I've selected two topics to discuss. First of all, we delve into the AI Act and its interaction with the iAccess project, and then specifically to determine how the AI-driven chatbot would be qualified under the Act. And second, we're also going to discuss very briefly one of the ethical considerations we had to tackle, and that's namely whether the chatbot would amount to a problematic companion chatbot. So we see on the first slide, as we all know, that the AI Act adopts a risk-based approach. Thank you. So we see that there are AI systems with minimal, with limited, with high risk, with unacceptable risk. So depending on the risk an AI system poses, different obligations are applicable. And due to the trialogues, we also now have general purpose AI models and systems covered by the Act. The regulation was proposed in April 2021 and will most likely be officially adopted in the coming months. So that would mean that it's going to be applicable somewhere in mid-2026 only. So while it's not yet strictly applicable at the moment or during the project, it's already for sustainability reasons that we take into account the obligations so that once the AI Act is fully enforced, the chatbot is already in line with all the obligations. So as explained, the aim of the iAccess project is to create an AI-driven chatbot. It's a generative AI-driven chatbot that supports children in accessing legal and practical information. And so one of the biggest issues we had was to qualify how the chatbots would be regulated under the AI Act. And to note, as all legal assessment, it really depends on the specific circumstances. So as mentioned already by Dori, it was really important to see what the chatbot could do and could not do. And as mentioned, the purpose is not at all to offer legal assessment, but rather to provide information about relevant laws and rights or providing helplines. So it can be compared to some kind of librarian that can retrieve information from a book collection it already has in response to a specific query. So while having that in mind, we determined how the chatbot would fall under the AI Act. And first of all, we had to determine whether or not it would just fall under the scope of the AI Act. And by that, we looked at the definition of an AI system, and the chatbot would fall under that definition. Because the chatbot, first of all, operates with a varying level of autonomy. So it means that it has some independence of action and has the capacity to operate without human intervention. Second, the chatbot can also show some adaptiveness in the sense that it can tailor its answers based on the matter of how the question is asked. And it also infers how to generate output like text based on machine learning. So now knowing that the AI Act will be applicable once the chatbot is there, a next step to consider is to see like which obligations are now specifically applicable to the chatbot. For completeness, we just briefly wanted to mention that in our specific case, the chatbot is not likely to qualify as a high risk or unacceptable practice, but we also looked at whether or not it would qualify as a general purpose AI model, because as some of you may know, then a whole lot of obligations would be applicable to the provider, the developer of the chatbot. So that would come with lots of responsibilities. We assessed it, and fortunately for us then, the chatbot would not be qualified as a GPI model. Rather, it's the underlying model that we use for the chatbot that qualifies as a GPI model. And the underlying model is GPT 3.5 Turbo or GPT-4 from OpenAI. That is a GPI model because, first of all, that is a model that is trained on a large amount of data. It deploys a significant generality and is capable of completely performing a wide range of distinct tasks, and it can be integrated in downstream systems. So that means that OpenAI, as a developer of GPT-4 and GPT-3, is subject to the many obligations under the AI Act. However, we also then looked at, is a chatbot a GPI system? And while the chatbot is an AI system that is based on a GPI model, as explained, it integrates GPT-3, it does not show a capacity to serve a variety of purposes. The only purpose the chatbot has is information retrieval and response generation. So in that sense, the chatbot that is being developed is just a traditional AI system in the sense of the AI Act, but nevertheless, the developer or deployer of that chatbot is subject to transparency obligations. And that means that children must first of all be informed that they are interacting with an AI system rather than with a human. And that message, and it's very important, that message must be tailored to children in vulnerable position. It must be age appropriate. So for instance, you could use visual means or simple sentences or a layered approach. And secondly, it's also required that the output is marked in machine readable format, and it's ensured that it's detectable as artificially generated, and that's something that our technical partner is taking care of. Besides the AI Act, as mentioned, I also want to briefly discuss one specific ethical consideration that arises whenever you're confronted with generative AI chatbots, and that's namely the risk of them amounting to problematic companion chatbots. So what is that exactly? When an AI chatbot engages in dialogues with users, they're considered conversational agents. And such conversational agents have a huge potential. They show lots of advantages, such as they offer quick access to support, you can interact with them anonymously, it's free or it's less costly. So the threshold to go to a chatbot is lower than as compared to a human sometimes. However, at the same time, such conversational agents they pose some very high risk. They can trigger psychological vulnerabilities, such as an over-reliance on the chatbot. They can promote harmful stereotypes or manipulate users by offering social companionships. So when a chatbot mimics social cues and human behavior, it can be that the users, especially vulnerable children, perceive the chatbot as human, and they can commit to them emotionally, they can become addicted to them, so it can disrupt human-human relationships, it can cause emotional dependence or an excessive attachment upon them. And the chatbots can then also be used to gather personal information, excessive collection, so that that data can be later on used to manipulate the users economically, socially, emotionally. So companion chatbots are truly problematic in generative AI systems. But for the AI Access project itself, the risk that the chatbot would amount to a companion chatbot was rather limited due to all the safeguards we had taken into account, and just also because of the objective of the chatbot. So first of all, the chatbot uses only a fixed answer structure. We also embedded some technical prompts. So that means that in the design phase, prompts were implemented that instruct the chatbot to refrain from showing too much compassion, too much emotions, too much empowering messages. So already in the architecture, it's the risk is limited that you could form a bond with a chatbot. And it's also most likely that the chatbot will not have any memory, so follow-up questions will not be possible. And so therefore, truly having an emotional bond with the chatbot is limited. And so with that, I conclude my part and my presentation. I'm happy to give the floor back and to have a discussion later onwards. Thank you.
Thank you, Victoria. Thank you, everyone. So thank you so much to the audience for joining us this lunchtime. So I'm Nessa Lynch, and I'll be picking up now to probably go from the quite specific discussions that my colleagues have led to some of the wider context. So I'm focusing today on children's human rights in the global regulation of AI, with the focus obviously on the incoming AI Act. So AI and children's rights is a very broad topic, and there are many different spheres in which children's rights can be impacted by AI. So some of these are algorithms in child protection, I think the social media and the online safety in relation to recommender systems such as TikTok has been very much in the news, and AI technologies in education. But what I'm going to focus on today is a couple of sites of inquiry, such as Children and Child Justice, the issue of border security in Europe, and the general national security context. And I'm going to chosen to focus on them in relation to the AI Act, because even though, as my colleagues have begun to describe, the AI Act offers a lot of promise in relation to the regulation of high-risk technologies and the prohibition of unacceptable uses of AI. The whole area of law enforcement, borders and national security is an area that even when the AI Act is implemented, as Victoria said, towards 2026, I think we will still see these areas, these sites of inquiries as places where the exclusions under the Act are such that member states will still have quite a good degree of wriggle room or gaps in regulations to use technologies. And also, as we'd understand as children's rights advocates, these sites of inquiries are places where the consequences of the use of AI may be quite severe in terms of exclusion from a jurisdiction, denial of refugee status, and child justice sanctions. So we've already heard today how AI can be used in children's lives, and my colleagues have also begun to describe the AI Act. So I'm not going to spend too much time on that, but I think just to make that point again, that AI, artificial intelligence, describes a really broad range of technologies, from quite simple operations to really, really complex. And I think a fantastic thing that has come out of the AI Act is, I suppose, an understanding of what AI is, and that risk framework, which we'll talk a bit more about in a minute. But again, designing regulation around emerging technologies is a really difficult task, because the ground is constantly moving, as we've already heard. But another point I'd like to make, and I think this shows up in the discussion of the chatbot, is that a lot of the scholarly literature and the human rights advocacy literature has focused very much on the risks of AI. And I think that's very proper. And in fact, I've contributed to that literature myself. So we absolutely know that AI can pose significant risks in relation to privacy, freedom of expression, freedom from discrimination, and so on. But it's also important to realize, as we've heard in relation to the chatbot, that AI can have significant potential in improving children's lives and protecting their interests and upholding and promoting their rights. So, for instance, a recent commentary by UNICEF, I think, has discussed really well how AI can benefit children in a number of spheres, such as access to education and providing accessible solutions for children with disabilities. And even in the child justice and law enforcement sphere, it's important to remember that AI technologies can also be really useful, for instance, in the law enforcement response to child sexual exploitation in the online space. So such as using facial recognition technology and optical character recognition to identify images, seek to identify alleged perpetrators, and to identify children so that they can be protected. So what I think my general point there is that we must look at the risks, but we must also look at the opportunities for children. So my colleagues have already talked about how the AI Act is, I think, the real first global attempt to actually regulate AI. So there has been, over the last 10 years in particular, a proliferation of what I would describe as principle-based guidance. So I think most large companies, tech companies, have some form of responsible AI principles. We've seen the OECD and other international organizations, I suppose, set down ethical principles such as fairness, transparency, etc. But the AI Act, as Victoria has really described, moves into the space of an actual regulation where we're going to have rules, and we're going to have, of course, the importance of penalties and sanctions where agencies fail to comply. So it's moving from that kind of high-level guidance into the actual realm of regulation. And similarly, I think looking at the children's rights landscape generally, we've seen bodies such as the Committee on the Rights of the Child begin to give us specific guidance around children's rights in the digital sphere, and which obviously includes not only AI, but a whole load of ranges of applications of technology such as online courts. And so generally the committee in its general comment on children's rights in the digital environment has focused on risks such as privacy, freedom of expression, but also I think made that point, which I just did, around AI also being a conduit for children to realise their rights. And a particular challenge, I think, which we're going to see in the spheres that I'm going to discuss, is that although human rights law traditionally focuses on the relationship between the state and the individual, what is a particular challenge for technology and AI is that development and implementation of AI technology has largely been led by tech companies and commercial interests. So rather than having a deliberative policy making process that decides that AI is the solution, what we've seen in a lot of cases is the conversations are between the technology supplier and the state agency. And it's only in the last couple of years where we've seen, I think, the public and the human rights approach being part of that conversation. So I think that is quite a challenge in relation to ensuring that we have a human rights compliance approach to AI, and of course a focus on children's human rights. So I'm going to move now to looking at 3 examples in this space of child justice, border security and national security, where I think as I started out this conversation, even when the AI Act is fully implemented, these are going to be sites where I think we are still going to see significant risks for children in quite vulnerable situations, because of the carve-outs that are present in the regulation for law enforcement purposes. So the first one I'm going to discuss is around live biometric surveillance technologies. So probably the most well-known of this is facial recognition, but it can include a very wide range of anything to do with those individual biometric characteristics. So I suppose when we first started hearing about the AI Act, I think many human rights advocates and children's rights advocates really thought that this would be the opportunity to completely prohibit live biometric surveillance within the European Union. But as the regulation has developed, I think we have seen that idea probably in the rear view mirror. And although most live biometric surveillance will be prohibited, what we've seen is the carve out of quite a large exception in relation to law enforcement. And I think this does pose some risks for children in child justice systems. So like other individuals who have human rights, if we take a child rights lens to live biometric surveillance, it can have some significant impacts on a child's rights. So we've seen around the world and in Europe, I suppose, children exercising their right to freedom of expression and their right to peaceful assembly, particularly in the climate justice movement. And so live biometric technologies are something that can have quite a chilling effect on people's right to protest. So the idea that you can be monitored, surveilled, identified, and perhaps some consequences then for your employment or your freedom of movement. And freedom from discrimination is another big issue. So although live biometric surveillance tools are improving in accuracy, we know that they are less accurate for ethnic groups. And we also know that they are most likely to be targeted against over-policed communities, which would include racial, ethnic and social minority groups. Obviously, privacy can be significantly impacted, and that can impact a child's right to their privacy and private life, particularly in public spaces when you're being monitored. So the Committee on the Rights of the Child has definitely made some commentary about they feel the risks of live biometric for children. But as we said at the start, I think it is important to also ensure that the legitimate uses of live biometric surveillance are preserved. So I mentioned already the example of biometric surveillance and identification tools in relation to the fight against child sexual exploitation. So we wouldn't want to rule those uses out that may have significant benefits for children. So as I mentioned, the promise of the EU Act was that this technology might be banned across Europe, but there is a significant carve out for law enforcement purposes. So the AI Act, when implemented, will still allow these tools to be used by law enforcement and for certain purposes related to crime control and to search for victims of crime and in relation to threats to life. So while even the Convention on the Rights of the Child itself does comprehend that idea that there can be certain situations where a child's best interests might need to be considered in the light of public safety, I think if we were to apply a child rights lens, as the AI Act requires us to do, it would only be in really extreme circumstances where we could comprehend the use of these kind of tools against children. And I think that will be something that states will really have to get to grips with, particularly said around children in public spaces or places where children might congregate. So moving now to biometrics at the border. And so what I mean by this are situations of border security where states are attempting to restrict what they talk as irregular migration and movements of people seeking asylum and unaccompanied minors moving across borders. And a real challenge here for regulation of really, I think, restrictive biometric technologies is that the EU Act completely excludes these type of activities for national security purposes. So if you're using a technology for a national security purpose, that doesn't fall within the AI Act. And I think many people, including myself, are concerned that it will be very difficult to distinguish in practice a law enforcement purpose from a national security purpose when we were looking at matters such as unaccompanied children seeking asylum and coming from war-torn areas of the world. So I think this is an area, again, where there's a large gap in the EU AI Act, and states will have to and should have to apply a child rights lens and not just use that gap in the regulation. So the third specific one that I want to address is predictive policing. So predictive policing has become prevalent globally and in Europe. So this is this idea that you might accumulate data on individuals and use AI-like tools to try and predict what individuals will cause a crime. So we've seen examples such as Gang Violence Matrix in the UK, where they collected information, including on children, and would hold that in a database of risky individuals. That's been quite problematic. It also includes things like hotspot policing, where you kind of gather data and try and work out where geographically people might commit crimes and then commit policing resources to that area. And as you might expect, the impact of these tools, because of the discriminatory manner in which the data is collected, they often have a disproportionate effect on children from minority and over-policed communities. And while it's quite legitimate that states and state agencies would gather data on children who are at risk, and in other, I suppose, areas we encourage that so we can have an evidence-based approach, we don't want to drag children into the net of the child justice system because they have particular risk factors. So again, the AI Act showed a lot of promise in prohibiting or significantly restricting these type of technologies. But again, the shape of the exception, where if you are using an AI tool essentially to support human decision-making in the law enforcement context, again, there's quite a carve out. That this will again be an area where the promise of the EU Act in restricting these type of surveillance technologies will not be realised. And so again, we're going to need to ensure that states apply that children's rights lens to protect children's rights. So moving to my conclusion, so I think what I would say overall is that this is a situation where, and like Cedric, I was glad to see that the final iteration of the EU AI Act contains that at least little bit of guidance around children's rights, that really for these type of technologies, we should not be seeing these deployed against children except in really exceptional circumstances like the convention anticipates. And of course, a real danger with the AI Act is that states might actually begin to use these technologies because they think that they're now EU approved. So again, it's up to member states still whether they're actually going to use these technologies. And again, if they apply a children's rights lens properly, I think it should only be exceptional. So my understanding of the EU AI Act process is that there was very little, perhaps none at all, participation and partnering with children. So again, as member states and agencies implement this and make decisions around technologies, it's essential that children participate in and partner around those decisions and designs. Children's rights impacts assessments will be vital around, again, any decisions to use or not use these types of technologies. And there are a number of really good frameworks being developed by various people. I do have some significant worries around whether tech companies are actually going to, I think, have that awareness of children's rights. We've seen in some cases, say, tech companies adopt children's rights or youth participation methodologies. But again, that reminder of how human rights, even if states are partnering and agencies are partnering with tech companies, that the responsibility is still there to protect children's rights. I'll wrap up, I think, just by saying that I think I was personally disappointed in probably how much we now have those carve-outs for law enforcement, for border security and national security under the AI Act. And I think it'll be incumbent upon us as advocates for children to make sure that children's rights approaches and children's rights frameworks are in place to ensure that really these are not used against children, or they are only used in really exceptional circumstances. So thank you. I'll hand back to you, Cedric, for the last part of this.
Thank you very much. Thank you very much, Nessa and Victoria, for all that information. And I invite everybody to add in the chat some question. We will be happy to answer. But perhaps to start with, perhaps with you, Victoria, if you agree. I found your last slide very meaningful, no? The fact that artificial intelligence companions should not behave like a human, basically. So I'm just wondering, do you think really that is totally evitable? And then it makes me think about how we can trust on this AI Act to provide those safeguards that we need to limit this extra development of chatbot and the fact that they might perhaps not safeguard enough children's rights. So yeah, what do you think?
Thank you. That's indeed a very topical question. So we see now that there's more use of these conversational or companion chatbots. We see it very much with the chatbot of Snapchats. That's a very problematic one. We also see it in other cases. There's, for example, one telling example here in Belgium, where there was a man that got in contact with a chatbot. I think it was Eliza, the chatbot. And apparently, because of the conversation, the man committed suicide. And then the woman, the wife, said that it was due to the chatbot. So these chatbots are truly impactful. Yeah. It seems sometimes superficial, their impact, but it can have like suicidal effects. So it's a thing that it's more and more looked into in literature, and the AI itself does not have an answer to that. It has some things to say. It adds some safeguards, as like, for example, transparency. So it means that whenever the AI Act is applicable, it means that there should be very well shown by the chatbot that you're interacting with a chatbot, not with the human. But that's it at the moment, the transparency obligations. Like, to fall under an unacceptable practice, it really demands a lot. The threshold is very high. So in my opinion, the AI Act alone will not be sufficient to counter the risk of companion chatbots. But as I mentioned as well, and I think you mentioned it as well, the chatbots also do not only have an emotional impact, but they can also like collect excessive data. And then we see it, for example, in the video game context, that they then be used to exploit them economically. And so for that, the AI Act itself does not propose many things, but we can fall back on things that we already have, such as the GDPR, the General Data Protection Regulation, that includes some safeguards for the processing of sensitive data, of the processing of children's data. So alone, the AI Act is not sufficient.
Yeah.
But when you take lots of regulatory frameworks together, that can help, taking into account that we can sometimes become a maze if you have to navigate in all these acts.
No, yeah, yeah. In a way, it's a little bit scary. Last webinar, we were lucky enough to get Birgit Scheiper from Strathclyde University, and she brought all the question of facial recognition, and you know, it remind me what you said, Nessa, about the biometric surveillance and then the predictive policy. And above all, around the right to protest. We are doing at the moment a lot of work on another topic, which is climate justice. And, you know, with all those protests, we see as well how children's rights can be violated when they express their opinion, they demonstrate in favor of climate change, or against climate change, better say. And they are, by all those technology recognized in the street, the parents can get in trouble, etc. So, you know, I mean, clearly between both of you, we can see the danger, no, of those technology. But let's be the devil advocate. Do you think, perhaps Nessa, that would be for you? But you think that those technology that we still call emerging, I'm not sure they're still emerging, but those technology can in some way benefit to children, and if yes, in which context? And at the contrary, that's the question we always coming back to us. If we decide, if we advocate for a ban of those technology, don't you think that potentially we will have a more negative effect?
Yeah, I think it's a really good question, Cedric. And I think throughout my talk, I was trying to pull that out as well around like the dangers in complete bans of these technologies. Because as I said, from a law enforcement perspective, particularly in the child sexual online space, you know, we've seen those type of biometric tools. I think a state probably has a duty under international human rights law to use those tools to protect children from abuse. So I think it's very important that principled regulation allows that flexibility, so that we're not kind of throwing those things out. And I think we've got to recognize as well that children and all of us are living our lives in the online world. And I think we're really seeing this in relation to social media, where I think there's been a backlash against AI tools such as recommender systems, really without consulting or participating or partnering with children. And I think it's a really protective kind of approach to say, oh, we need to take children's devices away from them in schools, and we need to ban them from TikTok. Whereas what we need is to recognize, take a children's rights approach, recognize children's evolving capacities, recognize the difference between a 7 or 9-year-old and a 17.5-year-old. So I think, again, the children's rights lens and the children's rights framework, I think, can allow us that kind of mature reflection and allow us to say what's in the best interest of children. Is it in the best interests of children to completely ban this technology? Probably no. And again, how do we involve children in regulation so that we are taking account of children as the full citizens of the future, rather than taking that kind of really paternalistic approach?
Yes, we need to protect them in this evolving environment. Unfortunately, they might know and understand better those emerging technologies than us. So, you know, yes. It's like a difficult run for us. And I feel older now after saying that. You know, coming back on the chatbot, there is some question on the chat about the chatbot on the chat, and Dora is actually answering those questions. But perhaps because you're involved in this project, Victoria, You attended several expert meetings we organized, and it was super interesting that at the end of the meeting we were much more lost than when we arrived, no? Because there is so many ethical consideration. So I was wondering, around the chatbot functioning as a conversational agent, do you think that there is other consideration, other ethical issues that we should take into account?
Yes, that's a good thing indeed to mention as well. The risk of potential companion chatbot is not the only ethical consideration that we had to take into account. We also took into account specific ethical considerations that are specific linked to generative AI, such as the fact that you could have algorithmic biases. So that refers to the fact that a chatbot or an AI system can generate biased outcomes based on inaccurate or underrepresentative input or due to the training. And since we have the saying garbage in, garbage out, the input that you give to an AI system is truly crucial. If that is biased, it's highly likely that the output is also biased. And then for our project, we try to keep that risk limited by limiting the input to legal acts and practical information, and the fact also that the chatbot is not trained on conversation with humans. And I can also mention another one, and that's highly discussed now in literature. It's the fact that generative AI system can generate inaccurate or fictional, but highly realistic output. And that's called hallucinations. So you could think of a chatbot in our case that it would hallucinate and make up a helpline, like a telephone number. And that's really problematic if you want to help children in vulnerable positions. And to tackle that risk, but do note you can never, ever, ever like fully ensure that your AI system is not hallucinating, but to limit the risk in any case, we had our technical partner that put in place many mitigation measures, such as they do a lot of coherence checks. They also input like domain specific information, or they also, that's their purpose, is that the output of the chatbot that we're currently developed refers to the source that the answer is based on. So you can also check as a human, like, oh, is it accurate or not? So there are many ethical considerations to consider as well, but we try to limit them in our project. But these ethical considerations are not unique to our project. I think whenever you're involved with generative AI or AI systems, you'll have to take into account not only the legal obligations, but also some ethical considerations.
Very good. Thank you very much, Victoria. And perhaps because the time is flying, Nessa, just very quickly, a last question. We are coming from a generation where computer were mainly rights. And now we enter in a new phase where with artificial intelligence, technology can be wrong. And it's exactly what Victoria say with those hallucinations, right? And at the same time, we are in this positive development of professional with this idea of techno-solutionism. Computer will save and justice system will be closer to the people, etc. And we will help more people, etc. When we speak with, let's say, head of IT in the different ministries and reform of administration, it's all pink, all beautiful, no? But we clearly understood from you and above all the example of national security purpose, and the AI Act, that there is a lot of issue to consider. So I was wondering if you think that at the end, apart from the EU level, if what government can do to protect better children's rights in this adverse context.
I think as well, the point I was making as well is that there is a bit of a danger that these technologies will now be seen as EU approved. So I think we need to urge member states that they can also make their own decisions about whether they implement these technologies or not. So for instance, Ireland's just had a legislative process around facial recognition, and we invited them to think whether it was actually needed in the Irish context. So I think as particularly with we have a role advocating in the EU, but we also have roles in our individual jurisdictions to urge our own governments, I think, to take a children's rights approach, which I think still allows deployment in extreme circumstances, but think whether we want these wide rollouts of is it needed in the particular cultural and social context of our jurisdictions. And I think, again, the children's rights framework allows us that framework to make those decisions while allowing, still room for use in extreme circumstances. So again, it's important to note this isn't an approval process for technologies, and jurisdictions and indeed EU agencies are still free to make their own decisions. It's a very legitimate decision to say, actually, no, this is available and we're not going to use it. So I urge consideration of that.
Yeah, thank you, Nessa. Yeah, we still have a lot to do, and it's not clearly the work is not finished yet. It's only the start. But thank you very much, Nessa. Thank you, Victoria, for your time today. Thank you to thanks to all the participants for staying for the lunch with us. We would like to invite you at the end of this session to fill in a little survey. But before that, with my colleague Dora, we would like to invite you to come back in September for another webinar just after summer. Hopefully, we will be all grown at that time. And we will focus more on the question about legal aid and artificial intelligence and the role of legal law firm and lawyers. So I leave you with that. Please stay tuned on LinkedIn and other social media to get the date, and don't forget the little poll that we share with you right now. Thank you very much.